On 8 July of this year, 2022, the Commission sent you a request for submission of the 5-year Declaration of Assets and Personal Interests. On July 15, 2022, you submitted your 5-year declaration. The Commission also asked candidates to voluntarily complete and submit an ethics questionnaire, and you submitted your ethics questionnaire on July 5 of this year. The Commission sent you a first round of questions on 8 August 2022. This round of questions included 10 questions with 28 sub-questions and 14 of which requested documents from you. Your responses were due by August 12, 2022. Instead of responding to the Commission's questions, you sent the following email to the Commission on 10 August 2022, and I quote, "I confirm the receipt on 9 August 2022 at 16:30 of the Commission request from 8 August 2022. Please be informed that I am available to give answers verbally before the committee to all additional questions, including any other questions which may arise. At the same time, I highlight that the limited time allowed to give answers and present the requested documents creates my state of impossibility to satisfy the requests from the Commission. The days of August 10 to 12, 2022. Based on the above, I asked to be invited to give answers before the Commission in the composition of all members, 6 members, on any date from August 22, 2022. Thank you in advance, Anatolie Țurcan." End of quote. On September 16, 2022, the Commission Secretariat sent you the following email, and I quote again, "Dear candidate Anatolie Țurcan, the Independent Evaluation Commission has not received responses to the questions sent to you on 8 August 2022. Your responses were due on 12 August 2022. The Commission is presently preparing for hearings pursuant to Law Number 26/2022, Article 12. Please be advised that Law Number 26/2022, Article 13, Paragraph 5, provides that a candidate shall be deemed not to meet the integrity criteria if serious doubts have been found as to the candidate's compliance with the requirements laid down in Article 8, which have not been mitigated by the evaluated person. Emphasis added. Article 3, Paragraph 4 of the Evaluation Rules of the Independent Evaluation Commission, pursuant to Law Number 26/2022, provides that a candidate may not provide information, documents, or other materials during the hearing if the Commission had requested these earlier and the candidate had not provided them within the time specified. If considered justified, the Commission may allow for exceptions. As you have not responded to the Commission's questions and requests for information, please be advised that unless sufficient justification is provided to the Commission, the rules will not permit you to provide information, documents, or other materials during the hearing that were the subject of the questions and the requests in the Commission's email dated 8 August 2022. End of quote. On October 5, 2022, you sent the following email to the Commission, and I quote, "By this message, sent on September 16, 2022, I communicate the following. I insist that it is justified and constitutes an exception to personally present the answers of the candidate Anatolie Țurcan strictly personally before the Independent Commission with reference to the alleged serious doubts regarding the candidate's compliance with the requirements provided for in Article 8 of Law number 26, 2022. I insist that the Independent Commission allow the exception of hearing me directly with the presence of all 6 members of the Commission. At the same time, I would like to point out that to my request for disclosure regarding the compatibility of the members of the Commission, T. Raducanu and N. Repchevsky, I received a vague and evasive answer that T. Raducanu was recused, in brackets, by whom, what is the information on this subject, and does it correspond to the criteria of transparency? Regarding the incompatibility of the member of the Commission and Repchevsky, I did not receive any answer and I do not know anything, although normally I would have been informed on this subject as well. P.S. I am waiting for the invitation to the meeting of the Independent Commission. Thank you in advance, Anatolie Țurcan. End of quote. On 10 October 2022, the Commission Secretariat sent the following email to you. And I quote again, Judge Țurcan, this responds to your email to the Commission of 5 October 2022. Law number 26/2022, Article 10, Paragraph 7, allows the Commission to request additional data and information from the evaluated candidate at any stage of the evaluation proceedings in order to clarify any uncertainties. The Commission sent you a set of 10 questions, including 28 sub-questions, out of which at least 14 requests for documentation on 8 August 2022, which you were asked to answer by 12 August 2022. On 16 September, you were reminded that you did not provide answers to any questions sent by the Commission. To date, you have failed to answer any questions from the Commission and failed to produce any documents requested, instead insisting that you permitted, in brackets, the exception, end of brackets, of being allowed to personally present your information and documents at the hearing. Commission Evaluation Rule Article 3, Paragraph 4, as you have been reminded, provides that a candidate may not provide information, documents or other materials during the hearing if the Commission had earlier requested them and the candidate had not provided them within the time specified. If considered justified, the Commission may allow for exceptions. To date, you have not provided any justification for not responding to the Commission's questions or requests for documents, only insisting that you be allowed to present them in person at the hearing. Please be reminded that Law number 26/2022, Article 13, Paragraph 5, provides that a candidate shall be deemed not to meet the integrity criteria if serious doubts have been found as to the candidate's compliance with the requirements set forth in Article 8, which have not been mitigated by the evaluated person. With respect to your inquiry concerning the recusal of Commission member Tatiana Raducanu, you have been provided the extent of the information that the Commission provides concerning recusals. As concerns your claim of incompatibility of Commission member Nadezhda Repchevsky, if you are contending that she should be recused from your evaluation, please note that the Commission Rules of Procedure, Article 10, Paragraph 2, require a call for a conflict of interest provision to be reasoned and submitted in writing or by email to the chairperson of the Commission at the earliest possible time during any stage of the proceedings. End of quote. On 13 October 2022, the Commission sent you a second round of questions. Your responses were due by 16 October 2022. Also, in this case, no responses were received by the Commission. The questions you were asked by the Commission which you did not answer, involved the following issues. In the first set of questions that were sent to you on 8 August 2022, we asked you to respond to the following questions. Number 1. According to your annual declaration of assets, you declared that you took a loan of 200,000 lei from a close family member. According to this declaration, there was 0% interest rate. You declared this loan for the annual declaration for 2013 and 2014, but you did not declare this loan thereafter. The Commission asked you whether a loan agreement was concluded, and if so, to provide the Commission with a copy. The Commission also wanted to know what the source of funds were from which this family member gave you this loan and any supporting documentation relating to such funds. And the Commission asked you what the conditions for the reimbursement of the debt were. The Commission did not receive an answer to these questions. 2. Since 2012, you have declared in your annual declaration that you and your wife have 3 real estate properties in Chisinau, 1 house and 2 plots of land. In relation to 1 plot of land, you have provided a description of this plot and a cadastral number, but in the cadastral system, this number does not appear. The Commission has asked you to clarify this issue. The Commission did not receive an answer to this question. On 3 June 2013, you bought a car, a Mercedes-Benz E280 CDI, model year 2006, which you sold on 14 May 2019. But in your annual declaration for 2019, you did not declare any income from the sale of this car. The Commission asked you to provide a copy of the sale purchase contract for this car and asked you to explain why you did not declare this income. The Commission did not receive an answer to these questions. At present, number 4, at present you do not have a car registered under your name, but you and your wife are making use free of charge of a car, Mercedes-Benz E350 CDI, model year 2014, that a close family member of yours imported in January 2018 and is registered as property in the name of that person. The contract to use this car free of charge was signed on 12 March 2018, but you did not declare the right to use this car in your annual declarations for 2018, 2019 and 2020. Only in your 2021 annual declaration did you declare the right to use this car. In addition, the market value of such a car in 2022 is estimated to be around 450,000 lei, which is almost 23,000 euro. But the total taxable income of this family member over the entire period 2012-2021 is substantially lower than the market value of this car. The Commission asks you to provide documentation relating to the import of this car in 2018 and relating to the lease contract between you and this family member. The Commission also asks you to explain why you did not declare the free use of the car over the years 2018, 2019 and 2020. The Commission did not receive an answer to these questions. 5. Over the period 2007-2015, you held 5 bank accounts. In the years 2014 and 2015, these bank accounts were declared, but not in the years 2012 and 2013. The Commission asked you to provide bank account statements for all these accounts since 2012. The Commission also asked you to explain why you did not declare these accounts in the 2012 and 2013 declarations. The Commission did not receive an answer to these questions. 6. One of your children studied abroad in Europe in the period 2016-2022. The cost of studying abroad, such as cost of living and tuition fees for the university, can be considerable and may add up to about 25,000 euros per year. This child has practically no taxable income declared in Moldova over these years. The Commission asks you for documentation regarding these studies abroad and asks you to provide information whether you incurred any considerable expenses in relation to these studies and to explain who paid for these studies. The Commission did not receive an answer to these questions. Another child of yours holds the citizenship of a foreign country and works abroad since 2017. He is also registered as a student at a university in Europe. The Commission asks you to provide information about these studies and who is paying for them. The Commission also asks you to provide information about the current employment of this child and about the foreign citizenship. The Commission did not receive an answer to these questions. 8. One of your children was donated a plot of land in a village close to Chișinău by a close family member. That family member bought this plot of land in 2011 for the contractual price of less than 1,000 lei. Both in 2011 and in 2021, this family member was represented by your wife in buying and selling the plot and the donation agreement. The market value of such a plot of land is now, in 2022, estimated to amount to well over 1.1 million lei, or roughly 57,500 euro. Furthermore, in the course of 2020 or 2021, a house was constructed on this plot of land. Your child has no income registered in Moldova. The Commission asks you to provide documentation relating to the purchase in 2011 and the donation in 2021. The Commission also asks you to provide an estimate of the value of the plot of land, including the construction on this land. The Commission furthermore asks you for information relating to the costs involved and the sources of funds used for the construction of this house. And finally, the Commission asks you why your wife represented this family member in 2011 and in the 2021 transactions. The Commission did not receive an answer to these questions. In 2021, one of your children and spouse became the owner of 2 apartments in Chișinău. One of them was bought on 29 July 2021 from a close family member of yours. This family member was again represented in the sale purchase agreement by your wife. The other apartment was bought on 26 October 2021. The total contractual value for these 2 apartments amounts to just over 2 million lei. In addition, in the spouse's name are registered 2 vehicles, a Mercedes-Benz E350 CDI, model year 2014, we've seen that car before, and a Mercedes-Benz GLE 350D 4MATIC, model year 2016. The market price of both cars for 2022 is estimated to be over 70,000 euros. That means around 1.3 million lei. The total value of the real estate and the 2 cars amounts to well over 3 million lei. At the same time, the taxable income of the 2 partners for the period 2012 to 2022 amounts to less than 500,000 lei. The Commission asks you to provide documentation relating to the purchase of these real estates and its financing and relating to the purchase of these cars. The Commission also asks you whether you or any of your family members have contributed in any way to the purchase of the real estate. The Commission did not receive an answer to these questions. 10. According to Law Number 26/2022, you were required in the process of your evaluation to declare persons close to you. In the 5-year declaration that you filled in, at point 15 of that declaration, you were required to provide such information. Under the law, close persons means, for example, spouse, children, persons related by blood or adoption, and a number of other persons. You did not fill in this question. The Commission then asked you to explain why you did not do so. The Commission did not receive an answer to this question. On 13 October 2022, the Commission sent you a second list of questions. You were required to provide your answers by 16 October 2022. In this second list of questions, we submitted 4 more questions to you. These questions are the following. 1. In your annual declarations for 2017 and 2018, you twice declared income obtained by you as social allowances for sick leave. The Commission asked you to explain why you declared this same amount twice. The Commission did not receive an answer to this question. 2. In addition to the question asked in the first round, the Commission sought information from you about 4 bank accounts that were not declared in the period 2012-2015 as required by the then existing legislation, and 2 bank accounts that may not have been declared in the period since 2016 as required by the legislation in force since 2016. The Commission asked you to explain why you did not declare these bank accounts and asked you to provide bank statements for all bank accounts for the period 2007-2021. The Commission did not receive an answer to these questions. 3. In the period 2013-2021, your wife held a bank account in euros with one of the banks in Moldova. In these years, she deposited a total amount of over 43,000 euros on this bank account. Her income in this period amounted to 35 lei only. In the years 2012, 2013 and 2016, you did not declare this bank account. The Commission asked you to explain the source of this money and to provide confirmation documents. The Commission also asked you to explain why you did not declare these accounts in the years 2012, 2013 and 2016. Furthermore, the Commission asked you to provide bank statements for the period 2007-2021. The Commission did not receive an answer to these questions. And 4. On 26 February 2019, your wife deposited 5,000 euro on her bank account and transferred it on the very same day to your child studying abroad. On 14 May 2019, your child transferred almost the same amount back on this bank account, and the next day your wife withdrew this amount of money from this bank account. The Commission asked you to provide the source of this money and to explain the purpose of these transfers. The Commission did not receive an answer to these questions. These were quotes of all the questions that we put to you. The Commission has been extensively involved in the pre-vetting evaluation of judge candidates for the Superior Council of Magistracy. No other candidate has totally refused to comply with the Commission's request for information to facilitate the evaluation process. Some candidates have responded in a timely and completely to up to 4 rounds of questions and requests for documentation. As a judge of the Supreme Court, who has also served on the Court of Appeal and in courts of first instance, I'm certain that you appreciate the importance of persons fully complying with the procedures of your court, and I'm certain you expect them to do so. As you have been warned repeatedly, under the Commission's procedures, Article 3, Paragraph 4 of the Evaluation Rule, a candidate may not introduce information, documents, or other material at a hearing that was earlier requested by the Commission, but not provided by the candidate within the time specified. Unless the candidate's failure was justified, of course. Do you wish to provide any justification for your failure to respond to all the Commission's questions and all the documents which the Commission requested from you? And now, Judge Țurcan, you have the floor to answer my last question. Do you wish to provide any justification for your failure to respond to all the Commission's questions and all the documents which the Commission requested from you? You have the floor, sir.
Thank you. Before I answer, I would like to inform you that I do not declare and I do not declare recusals for any of the members of the Commission. In the very beginning, esteemed Chairperson, you did not ask me about recusals. In your speech, you mentioned that I have personally asked to be informed who asked Madam Raducanu to recuse herself. To this day, I did not get this information as to who asked for her recusal. As regards Madam Hriptievsky, I only wanted to know it, or I only asked that she herself would inform the Commission members and the candidate about her compatibility or incompatibility, and as to whether there is any conflict of interest. So, considering her as a member of the Commission, and I did not receive an answer to that question. I was only informed that I could declare a recusation or ask for a recusation. Answer that, I hope you understand, is not satisfactory from my point of view. Now, regarding your question as for me personally justifying my refusal, but I did not refuse. The refusal to provide information. Here, I justify my refusal to provide information. There's Article 6 of the Law 26 that we referred to, letter C, F, gives the Evaluation Commission the possibility to collect, I highlight, to collect and check any data relevant for the evaluation of candidates. F says ask for information from individuals, legal entities, and public entities. There we go, you can ask for that information. As a very busy person that I am, examining files and doing my base job, I cannot do the activity of the independent commission instead of the commission. And in Article 6 and also Article 12 of the law that was mentioned, of the Law 26, that is, pay attention please to point 4, that provides for the rights of the candidate. They are to participate in the meetings of the commission and to provide verbal explanations. That's my right. And no regulation whatsoever can regulate deprivation of this right, because you said that the regulation would allow the Commission to deprive the candidate from the possibility to provide explanations. Please go back to your regulation in such a circumstance. In addition to this, I would like to highlight that there's paragraph 5 of Article 12, 5 of Well, it says that at least 3 days before hearings, the Commission was to present to the candidate the materials of the evaluations, the discovery. I don't know what materials you have. And my key reason to justify why I did not start to collect the documentation and the contracts and agreements from educational institutions from abroad, and the IDNP that was asked by I don't know who from the Commission, maybe even not by the members of the Commission. Somebody have asked for the IDNP of my son, who has the citizenship of another country. So all of the information that was sought by the Commission, I personally, I have absolute justification for that, and I can sit down and argue this, but because of lack of time, I will not do this now. I will do it later if that will be required. But I believe that all the questions, all requests from the Secretariat of the Commission to me, well, in no way are they, and in no way do they mean the existence of serious doubts that you refer to when you also refer to Law 26, where you say that if there's serious doubt. As for serious doubts, I have not found any of them. Any person has the right to be informed what exactly is serious doubts about when it comes to the integrity of that person, or when it comes to the actions undertaken by that person. If hypothetically the Commission believes that the candidate has hidden away some revenues, or that the candidate has transferred some amounts to people who are relatives but not members of the family, the only family member for the candidate is the wife. So either any doubts, the Commission should have told me about the doubts. What were those doubts about? This, however, has not taken place. The Commission did not inform me, the Commission did not describe what the doubts are about. That is my answer to your question. When it comes to explaining in a step-by-step way all those other questions, I am ready to provide explanations as provided for in the law. As we can see in Article 12, the rights of the candidate, that is paragraph 4, Article 12, paragraph 4, which sets out the rights of the candidate. I can answer for every separate point with regards to my sister, to the sources of her revenues, and so on and so forth. For every separate point, I'm ready to provide explanations today in front of the members of the Commission, as I've kept insisting on. That is, if you want me to provide explanations. If not, then well, I've already answered your question. Now, if you want me, I can provide answers to all of the questions now in front of the Commission. I insist that I can provide answers to all the questions that were raised in the first round, even where it comes to the 4 specific questions that you made reference to, that they were sent on the 13th of October, did you say? I've just seen them right now in the corridor before I came in. I haven't seen them, I haven't received them before. I will check the mailbox, but I think I didn't even see them on my email box, these additional questions. I received them just now, but I'm ready to answer them too. If you want to, you can ask me. You don't even have to ask me. I can read them out loud because I printed them out, and I can provide answers and explanations to any of the questions. And then, if that'll be required, you can, or the Commission can ask for documentation from Europe, from the countries where my daughter studied. The Commission, let the Commission look into what my son is doing. I will not demand of my son to give me explanations, to me as a father, as to what he is up to now at present. There is the Constitution, there is the Universal Declaration of Human Rights, there is the right to private life, and there is criminal liability in the Criminal Code of Moldova, Article 2001 prime, that says it says in a very interesting way that a member of a family, when that member initiates some investigation actions against another member, can be held liable. I have respect for my family members, for my close relatives, and I am not investigating and looking into who does what and what money they have. But subject to my own responsibility as a judge, at risk of being held criminally liable, let them only try. I am not hiding any revenue. I cannot be accused of illegal enrichment or of anything else. And I have nothing to hide, because somebody, maybe not the Commission, somebody has arrived at the incorrect impression that the only candidate that did not answer in writing to the questions, Anatolie Țurcan, not that it didn't comply, I guess that's the better word, did not comply with the requests of the Commission. The Commission has a budget. The staff, the Commission is paid. It has the possibility to hire people, to collect all this information. It has the possibility to ask for documents from the cadastre and so on and so forth. And a judge of the Supreme Court of Justice cannot just leave any work that he does aside, to put it all aside, especially in our country where the act of justice is hard to apply and there are people waiting for years for justice to be served in their cases. So I cannot just leave that all aside and go to Denmark or whatever other country. Sorry, I said the country. I even named now a country. So just to go there and find all this information. Over to you, Chairperson.
Thank you very much for your clarifications and comments. My question to you was to provide any information as to why you were not able to provide information earlier on. And in your comments, I have not been able to hear any reasons for that. Of course, you are as a judge very busy, and we, of course, as Commission, we fully recognize that. So do we in relation to all other candidates, and as I mentioned before, all other candidates have been able to provide information, and in practically all cases also within the deadlines that we have put. Under those circumstances, I think I am not in a position to now give you the opportunity to give answers, because we have given you the opportunity to do so in writing after the first request for information on August 8 and the second on October 13. I think as Commission, like you do as judge in your own proceedings, as Commission, we like to follow the procedures as we have them, and we have seen that that is fully compliant with practically everyone. Under those circumstances, I don't think I would see a reason to make any exception for a candidate who does not provide a clarification for the reasons why he was not able to give answers earlier. With that being said, I would therefore now give you the opportunity to make a brief closing comment at the end of this hearing, and then after that we would wrap up. So I would like to give you the floor, Judge Țurcan, to give a brief closing comment if you would like to, and after that we will close the hearing. Go ahead, sir.
Understood. So as regards closing remarks, so you don't want to hear the explanations, in violation of Article 12, paragraph 4 of the law 26 that sets out that the candidate has the following rights. A. To participate in the meetings of the Evaluation Commission and to provide verbal explanations. If you do not want to observe the law, number 26, then just say it out loud, straightforward, and I would like you to recuse yourself because you did not confer with the other members of the Commission as to whether it is allowed for with regard to whether Țurcan, as a matter of exception, is allowed to provide explanations or not. You would like to close the meeting immediately with some farewell remarks. I will not have any farewell remarks, any closing remarks, but before I do bid you farewell, I will be waiting for the other 4 members of the Commission to examine my request of recusal, because the grounds for such recusal has appeared spontaneously just now on the basis of your conduct, that by referring, you refer to the regulation and you ignore completely Article 12 of the Law 26 on the evaluation of candidates.
Thank you very much for your closing comments. I think I have been very clear in the procedure that we apply, and of course also prior to this hearing, the Commission has discussed the way to proceed in relation to this process and the exceptional situation in which we have the hearing this afternoon. So I feel that I'm fully competent to speak on behalf of the Commission. With that being said, and with not having heard any reasons explaining why you were not able to provide any information earlier, I would suggest that we come to the end of the hearing. The Commission will now, of course, withdraw for deliberations. A recent decision will be delivered later, and as much as possible, the Commission will strive at delivering a decision within a month after the date of the hearing. I declare the hearing closed. Thank you very much.